usher, aren't you? Are you the only one that's going to be in here?
Yes.
I think, John, that you could probably sit along here then, couldn't you?
It's not socially distant from the judges.
Oh, okay.
Can you see anywhere? Do you need a computer?
I've got my laptop with me. I could push there. In the middle here?
I'm not allowed to sit on that row apparently. I have to sit there because I'm not allowed to sit there.
Oh, aren't you?
No.
Somebody does sit over.
I mean, you could sit there, but you haven't got a desk, have you?
I'll manage. Yeah.
Okay.
Where's the nearest place to get some water?
The kitchen up the other end. It's supposed to get bottled.
Yeah, we've come over from the Rolls building, so I don't know.
I see. Court rise. appeal in the matter of News Corp UK and Ireland Limited
Yes.
and the Commissioners for Her Majesty's Revenue and Custom.
Yes, Mr.
Well,
Fleming.
in this case, I appear on behalf of the Commissioners, together with my learned friend, Ms. Mitrofanos, and my learned friend, Mr. Peacock and Mr. Brown, appear for News Corp UK, sometimes known as News Corp or sometimes News UK. They are the
Yes.
publishers, as you know, of the Times, the Sunday Times and the Sun. Before I turn to the appeal itself, I'm conscious that I have a
Just one moment, Mr. Fleming. Yes. Yeah, just before you start, Mr. Fleming, my Lady Justice Simler and I should perhaps say that we are subscribers to the Times Online and have been, in my case, been subscribers to the Times Online since it began. I can't see that should make any difference, but we thought
we
we'd tell
would
you.
find it helpful if that was the position, because it's useful to know what it is without going back just to the FTT.
We certainly know what it is. Thank you, Mr. Fleming. Yes, sorry, carry on.
No, not at all. Lord, I'm conscious that we may have breached one of the COVID requirements because I have a bundle of hard additional documents. I hope you've had them all electronically, but if not, they're in front of you. Can I just run through what they are?
What, this is this thing?
This, yes.
Well, I haven't had them electronically, and I would like them electronically. I don't really use paper, Mr. Fleming.
I will make sure that they are. If I could run through what's in the packet.
Yes.
First of all, there's the case from the Supreme Court, which was mentioned yesterday, the FII case.
Yes.
There's a substitute page 3 of the authorities, for anyone who needs the physical copy. That's the earliest of the VAT directives. There's then a document from the learned friends, the update to Bennion, towards the end of the bundle of authorities. And then there are two core bundle documents, possibly a third if you haven't received it. That's our skeleton argument with authorities references. That should have been sent.
We've got that electronically, thank you.
Yes. And the other is not the most significant document, but the replacement statement of case by the commissioners before the First Tier Tribunal. The one that you would find at the right page is a completely different case. So I will make sure that they're all sent electronically.
This is in the supplementary bundle.
No, yes, in the supplementary, quite right. It's towards the end, you'll see it's the consolidated case at page 75. And the one you will find there is a different case in time. Interesting case, but not the right.
I think we were sent that earlier in soft copy.
I was just, I'm sorry to start with a paper chase.
I wonder if you could just give me 30 seconds, Mr. Fleming. The HMCTS has been kind enough to give the judges of the Court of Appeal, including me, a new computer yesterday, but what they have not completely catered for is setting it up so that it works in court, which I'd like just to do, if I may. It won't take me a second. Good, yes. Thank you, Mr. Fleming. Let's organise that.
May it please you, Lord, my ladies, this is an appeal by the Commissioners from the decision of the Upper Tribunal released on Christmas Eve last year, reversing the decision of the First Tier Tribunal released on the 7th of June 2018. It's an important decision with consequences for taxpayers and for the revenue because it sets, as we see it, a different approach to the categorisation and expansion, that we will put it, of items which are currently zero rated to include a whole host of potential candidates also to be zero rated. The appeal is limited now to 2 grounds set out in our grounds of appeal, referenced in the core bundle at pages 119 to 125. The factual findings of the FTT, which were the subject of a 3rd ground of appeal, remain unchallenged as that ground was not permitted to continue. If the court accepts the argument that we set out in our 2 grounds of appeal, either one or the other, in the 2 grounds, then the respondent's notice comes into play. That's core bundle page 80. And that is its appeal to the FTT should have been allowed on the basis that there was a breach of the fiscal neutrality principle. And that ground was not considered at all in its judgment by the Upper Tribunal. And you can see that at paragraph 103, core bundle page 112. On fiscal neutrality, you will not see in your papers a skeleton argument from the Commissioners, because the Commissioners agree with and rely on the decision of the FTT, and that's their paragraphs 207 to 232, which is in the core bundle. You do have, if it helps, the the skeleton arguments for the Commissioners both before the FTT and the Upper Tribunal on fiscal neutrality. They're both in the supplementary bundle. The FTT is at page 139 and the Upper Tribunal at page 47. At the end of these submissions, if the court will permit me, and I'm conscious that it is my learned friend's respondent's notice, I was intending to make some brief supplementary submissions on fiscal neutrality.
Why don't you leave that to reply?
Well, I'm happy to, my Lord.
Well, that's the usual way of doing it, Mr. Fleming, isn't
I'm
it?
ready to go at the end of this, or leave it to reply.
And just while you're, while we're on that kind of thing, what timing are you expecting, and have you agreed with Mr. Peacock?
We were just talking about it as we were outside. We hoped in a day, and there's quite a lot of case law in here.
You hoped what?
In a day, but we think we'll drift into tomorrow and finish
Right.
about lunchtime tomorrow.
Yes, okay, well, then that would be a good ambition, very good.
Well, that's the intention, proceeding, of course, on the basis that judicial interest is not sparked along new roads. Well, I'm taking the decision of the Upper Tribunal and the FTT as read.
Well, you can take that as read, and all the skeletons and some of the cases, yes. There's quite a lot of reading gone on, Mr. Fleming.
I had assumed that. The facts we can take from the decision of the FTT, where it found, particularly as to content, and I quote, the content of the digital and newsprint editions was indeed fundamentally the same or very similar. That's the FTT at paragraph 1 of 3, and it had similar characteristics to those of the newsprint editions. That's paragraph 150, and the key factual conclusions are at paragraphs 150 to 159. The UK currently applies a zero rate of VAT to physical publications, books and newspapers, under what is now known as a standstill provision, which allows member states to retain the zero rate that they had in place in 1991. For the UK, that really goes back to 1975. The 1991 reference is to later joining member states. And the zero rate does not extend, we submit, to e-publications, and there's a basic reason. As electronic services, these supplies have, until very recently, been mandatorily standard rated under the EU VAT directive, whereas books and newspapers in the UK have historically been excluded from purchase tax pre-1972 and then in the 1972 Act. It may assist, it may not, but could I show you the current guidance from the commissioners? It may be a document you have seen or you haven't, just to set out the broad position and to just show you very briefly some of the fine lines that have to be drawn or have been drawn over the years between zero rated and standard rated, even within the world of physical publications. This is right towards the end of the authorities bundle, and the electronic page 649. It's almost the last document, probably is the last document. It's headed HMRC guidance, and it begins substantively at the foot of page 650, telling the reader what this 2016 update notice says, but similar versions have existed before 2016.
Now, you say 650, that's 650 in the bottom right-hand corner,
Yes,
is it?
yes.
Yes. I mean,
Should work as the same page.
No, I'm afraid it doesn't. It never does. But I've got it, thank you.
You'll see right at the foot of the page, my lord, what law covers this notice.
Yes.
The Value-Added Tax 1994 Section 30 provides for zero rating of goods listed in Schedule 8 of the Act. Schedule 8, Group 3 sets out books, etc. And then over the page you get the items which we'll come to when we look at the legislation. And in 2, the format of the Group 3 items on page 651. The words in Group 3, this is of course the Commissioner's views and no more nor less than that, but I want to show you in 3 paragraphs the Commissioner's position. They are used in their ordinary everyday sense, means they are restricted to goods produced on paper and similar materials such as card. Most items qualifying for the zero rating will be products of the printing industry, including items printed in braille. But goods which are photocopied, typed or handwritten will in some cases also qualify. Goods containing text in other formats, such as audio or video cassettes or CD-ROM, are standard rated. CD-ROM will come up again when we look at the European provisions. This includes the storage and distribution of text by fax, email, microfiche, or any similar process. Transcripts or printouts made of such information are zero rated if they are supplied in the form of books, booklets, brochures, etc. The supply of text by electronic, including e-books, via the internet or similar means, is also standard rated. Such supplies are of services, not of goods, and different VAT rules will apply to them, such as those on the place of supply services. See Notice 741A, place of supply. Lord, I'll be coming back to the difference between goods and services more than once in the submissions. And then the meaning of Group 3 items. The meaning of the individual items is explained in detail below. Whether a particular item falls within those meanings depends mainly on its physical characteristics and function, but also to a lesser extent on its content. And over the page you then have all the items in Group 3 addressed. Foot of the page, books and booklets. The next page, for Lord 652, is brochures and pamphlets and leaflets. Items with areas for completion. And then on 654, there's newspapers. You'll see how it's described in this document. Issued once a week in continuous series under the same title. Each issue is usually dated or serially numbered. They usually consist of several large sheets folded rather than bound together and contain information about current events or local, national, etc. And then journals and periodicals, picture books, painting and dot-to-dot books. And as you turn the page or go down the screen, my lord, you'll get to page 657. 656, I should call that, music is one of the issues that comes up when examining the judgments below. Music is dealt with at 3.9. So printed, duplicated or manuscript music of all kinds is 0 rated, but music rolls and blank music manuscripts are standard rated. But that's one of these fine lines. And as you go on to the next page, items not included, you'll see there's reference to posters, stationery, letters, incomplete publications, and then photocopies. And over the page there's related supplies. And then you get to loans, hires and shares, which is relevant to notes when we look at the group. But without going through this in detail, could I ask for any free time just to go through the pages, but then turn to the liability of some common items, which is paragraph 8 on page 664, right at the foot of the page. And in then 655 is guidance from the commissioners, no more than guidance. In the list below we give our views of the liability of items which are commonly the subject of queries about the 0 rating for books, etc. However, you should not assume that an article is 0 rated under Group 3 just because it's not shown as standard rated, or determine liability by referring only to this list. You must satisfy yourself by reference to the general body of guidance in this notice.
I'm sorry, are you on 655?
665.
Oh, 665, sorry.
And then over the next few pages, in fact, several pages, you'll see the fine lines drawn between, just starting right at the beginning, accounts books are standard rated, but accounts fully printed are 0 rated. And if you just turn page after page, you'll see that over the years since 1973, the commissioners who have the task of administering the tax have been putting together their views on items which are either 0 rated or standard rated. So you have, for example, on, well, I won't take you through them, you'll see the example. Some are referred to as books, some are referred to as journals, some are, for example, a log book is standard rated, whereas a loose leaf book is 0 rated. And they've been these fine lines drawn over the years.
So the point you're making is that these fine lines are really thrown to the wind by the decision that makes everything digital.
Yes, and not just this group of, not just this item, and all the items in this group, because the debate in Europe for years has been about books and e-books. And we, with the benefit of always speaking, blown all that away. Of all the member states, UK, with this little bomb in its back pocket, can open up all of these 0 rated items into the transfers of goods to services and all of the problems that Europe has been having on this issue, which according to the Upper Tribunal is irrelevant, is not happening here at all. And I make these submissions, of course, knowing that we may not be in Europe for very long, but this covers a period when we firmly were.
Well, I mean, VAT is a matter of European law
Exactly.
at the moment.
European law with European principles applying to it, and not just fiscal neutrality, which is implied by the words in Article 110 when we get there, but also the principles of strict interpretation, the approach that there shall be no extension of exemptions and no expansion of the scope, and legal certainty, of course, is an important European principle. So, as I said, matters of considerable public importance in relation to this case. The first and main issue in the appeal is, can the principle of always speaking, and I pause there, before the FTT, the learned friend's argument was a combination of submissions saying that the natural meaning, so without reference to always speaking, the natural ordinary meaning of newspapers in this group included his client's digital products. He then brought up always speaking. By the time we get to the Upper Tribunal, although there's a reference to different principles, the case really determines, hinges on always speaking. So it's really always speaking or nothing on this area. So can the principle of always speaking properly achieve the effect of including electronically supplied services in the term newspapers in Group 3 of Schedule 8 of the VAT Act 1994? So that's a composite ground covering our two grounds. Can the principle properly achieve the effect of including electronically supplied services in the term newspapers in Group 3? And the second main issue, if the answer to that first question is no, can the same result be achieved by the application of the EU principle of fiscal neutrality? And that's the respondent's notice, and we say, of course, that the answer to both questions is no. The supply we are concerned with, and it now does help to have knowledge of at least two members of the court, it is a supply by subscription of a bundle of services, no property passing, delivered over the internet or an electronic network to be downloaded into a device, a computer, such as a smartphone or tablet, and there accessed. It is an online digital service. As I said, ownership does not pass. The statutory framework is, of course, central to these submissions, central to this appeal. We have, I hope helpfully, put almost all the provisions in the annex at the end of our skeleton argument, and we summarise the submission in our skeleton argument.
Let's put one factual point. When you say it's a subscription,
Yes.
can you just decide to download one day?
No.
You have to subscribe for a minimum period.
I think so. Before the FTT, there were conditions as one of the documents, which I will make sure you can see. What's happened over the years, if you go onto your laptop, computer, or phone, if it's particularly taking Apple as an example, you tap on the N for news, and you will have opportunities to access potentially hundreds of newspapers, periodicals, journals from around the world. Some of them, and take the Washington Post as a good example, much accessed over recent years, recent months, for understandable reasons. If you tap on any of their stories to read them on your computer, you might be met by a firewall, and it will say subscription only. Whereas for others, such as CNN News, you tap on CNN News and you read what you can see, and there will be videos as well. On the Times and the Sunday Times, if you tap on their little box, you will be met by subscription only. And to get to the written or the video content or the audio content, you will have to pay. I think it might be monthly as a minimum, but it might be annual, I don't know. I also confess that I've been a subscriber from the outset. So it's subscription only. The difference is it's a service, and it doesn't transfer any property to the recipient. There's no supply of the phone.
It's I'm not just asking whether it's a service or not, whereas anyone can go into a newsagent and buy today's issue of the Times, and that might be the only one they buy this year.
Yes.
But as my understanding is, as a subscription, you can't just get today's one if you
Yes.
for however much it is.
You can't get it without subscribing, but that doesn't apply to all news you can access online. But it does apply to this respondent. And when you get it, you will, as you'll see from the from the decision of the tribunal, factually, you will get access to thousands of back copies, and you will get access on a daily basis to at least 3 updating editions, as they're called. So your news is updated without going back to the newsagent. And one of the points that was made by the respondent to the First Tier Tribunal, unlike most of the world, you'll be able to read content of the Times on Christmas Day, because it comes to your machine, not to your letterbox. And we say, of course, all of this is significant. The differences, however, were not so significant that we could pursue ground 3. The statutory framework, could I just, in a few bullet points, say what we say you glean from it, and then if I could take you through it in more detail. What the court will glean from the framework, and already I can see that I am repeating the submissions because it's almost impossible not to. First, the UK zero rate, which in European terms is not called zero rate, it's called exemptions with deductibility of the VAT paid at the preceding stage. To use the term. So the UK zero rate set out in 1972, that's the Finance Act 1983, the VAT Act 1994, the current VAT Act, insofar as it covered books, newspapers, periodicals, etc., was confined as a matter of fact to printed physical goods. Second point, both in the UK and in the EU, based on community-wide principles, goods and services are different kinds of supplies. And of importance, different place of supply rules applied, at least until 2015. Third point that I hope will come through is that the European Community permits zero rating, but with standstill dates. In particular, taken from the 6th Directive and the Principal VAT Directive, 31st of December 1975 and the 1st of January 1991. Those are dates that you'll see in the legislation.
Sorry, give me those dates again.
The 31st of December 1975,
Yeah.
that's the 6th Directive, Article 28, and the 1st of January 1991, that's the Principal VAT Directive, Article 110. That, as I said earlier, is because new members had joined.
But Article 110 is nonetheless effective in its present form to the UK.
Yes, yeah, and covers all of this period. It was brought in at the end of 2006. November 06 is my recollection. The exemptions must not only be subject to this standstill point, but they must be in accordance with community law. That's in the text of Article 110. And that potentially brings in the concept of fiscal neutrality, which is, and I emphasize, a European principle. It's not a domestic one. It also brings in, we submit, respect for the decisions of the CJEU in relation to exemptions generally, and also the need for a strict interpretation, because this is a derogation of the obligation on each member state to charge and collect tax. In relation to fiscal neutrality, and I won't, of course, develop this now except in reply, but some of the cases I would take you to deal with it at the same time.
Well, I mean, if it's convenient to deal with cases and they cover fiscal neutrality, then
I'll do that.
And do it. I mean, I was just suggesting that you shouldn't reply to points in advance.
No, the point that comes out of those cases when looking at fiscal neutrality, and we say it must also apply to a strict interpretation, is you cannot extend the scope by fiscal neutrality. And that's why, according to the First Tier Tax Tribunal, fiscal neutrality does not assist the respondent. So with those few words of introduction, could I take you through the EU and the domestic statutory framework? And I hope as we go through that I can make one or two submissions which will save going to some of the cases.
Are we looking in your appendix?
No, can we use the original, Gerald? Because
Yes.
the reason for that is, although we have set out everything that's central, there are one or two provisions which are not in the annex, and it would be easier to stay within the bundle. The bundle should be divided into EU legislation and domestic. So European legislation should start, and I hope the law starts in your computerized version on page 2.
Yep.
But close. If not, I'll keep adding the right number.
Well, funnily enough, it changes. So it is page 2, whereas by the time you get to page 678, it's 8 pages out.
Ah, that may be because of the addition of Bennion that hasn't picked up the numbering, because that update is about 8 pages. I'm at the easy.
Don't worry, I'm
You're used
capable of dealing with it, Mr.
Okay.
Benning.
Can we start with? If we could start
Page
with
2. Let's
page
start
9.
with the second council directive.
Page 9 is the easiest.
Oh, page 9.
Page 9. This is to start with the permission that you find in the legislation, more recent rather than the first directive. This is the last version before the principal VAT directive, and you can see at the top of the page it's dated the 1st of January 2006.
So this is the 6th directive.
6th directive, maybe, yes. So this is Article 28, and halfway down the page you'll see Article 28.2, and as you go through the text you will see that there are various permissions. And there should be a letter M5 against the 2. M5 is taken from the previous page, page 7, sorry, 2 pages, which is the dates of the various amendments. So what you're looking at page 9, although dated 2006, is an amendment from 2002, 19th of October 2002.
92.
92, sorry. Yes, 92. I've written 2000. So it's a long-standing provision. And if we can look at just 2 elements of this. 2A, so it's notwithstanding Article 12.3. 12.3 you needn't go to. It's an obligation on all member states to charge VAT at a minimum rate of 15%. Whatever the rate was. So notwithstanding that obligation, the following provisions shall apply during the transitional period. The transitional period has been going for a very long time. Exemptions with refund of tax paid at the preceding stage, 0 rate, and reduced rates, lower than the minimum rate laid down in Article 12.3, in respect of the reduced rates, which were in force on the 1st of January 1991, and which are in accordance with community law and satisfy the conditions stated in the last indent of Article 17 of the Second Council Directive may be maintained. And that's what takes you back to page 3. And page 3 in the original version, which you may still have, was unhelpfully paragraph 16 and paragraph 17, whereas what I've just provided for you should be Articles 16 and 17. And apologies for that. And you'll see that Article 17 is as follows. with a view to the transition from the present system of turnover taxes to the common system of value-added taxes, member states may adopt transitional measures, apply reductions, exclude certain transitional periods, etc., and then authorise what follows, and that's all abolished until you get to 5. Provide for reduced rates or even exemptions with refund if appropriate, that's 0 rate, of the tax paid at the preceding stage where the total incidence, Such measures may only be taken for clearly defined social reasons and for the benefit of the final consumer. So this you'll see as a constant. You can exclude certain items, but it must be for clearly defined social reasons and benefit of the article.
What did you mean by it's all abolished?
Sorry, Article 16, so Article 17, there are 5 indents. First being adopt.
Yeah.
All of those were repealed by the 6th directive. And what was left in place was the 5th indent.
I see.
And if you go back to where we were, my lady, you'll see there's a reference to the last indent. Back to page, if I could go to 9 slowly and pause at page 5, because you'll see that reference.
It's a confusing method of notation, the last indent of Article 17. But anyway, we understand now.
And you can see the language first used on page 5 when there is the 6th VAT directive as passed in 1977. And you'll see the transitional provision then has a date of 1975. It's Article 28.2. Whilst I'm on that page, could you just pause at 28.3? During the transitional period referred to in paragraph 4, we don't need to go to it, member states may continue to subject to tax the transactions exempt under Article 13 or 15 set out in Annex E to this directive. And then, if I can go back to where I was on page 9, you'll see that that becomes Annex H. So when you get to Article 28.2a.
Sorry, you've lost. Oh, yes, I see. In B, Annex A.
B. So in A, you get this reference to the last indent of Article 17. And importantly, the words may be maintained. And then in B, member states which at 1st of January 1919, in accordance with community law, applied exemptions with refund of tax paid at the preceding stage, 0 rate, or reduced rates lower than the minimum laid down in Article 12.3 in respect of reduced rates, to goods and services other than those specified in Annex H may apply the reduced rates to any such suppliers. So this brings in a change, and
So you're saying that what's Annex H there used to be Annex E if we look at page 5. Sorry?
Yes.
Yeah.
And Annex H is on page 13. And the reason for showing you this is to show you a set of, or a consistent theme throughout the EU legislation that deals with the same topic that you're being invited to deal with today. So on page 13, my lady, Annex H, as at, it says at the top, as at 2006, but M5 is there again, so it's back to 1992. And at 6, you'll see, before we get to right at the top, in transposing the categories below,
Sorry, which page are you on now?
page 13.
Yep, thank you.
It's the list of supplies of goods and services which may be subject to reduced rates of tax. And at 6, supply, including on loan by libraries, of books, including brochures, leaflets, and similar printed matter, children's picture drawing or colouring books, music, printed or in manuscript, maps and hydrographic or similar charts, newspapers and periodicals, other than material wholly or substantively devoted to advertising matter. That's remarkably similar in terms to what we find back in the 1972 domestic legislation. And when we move down the line, you will see it was necessary to amend this language to bring in CD-ROMs, which was considered to be a development at the time.
So is this, so I haven't quite understood this before. So the Article 110, it's not then sort of open in the sense that anything that was 0 rated at the particular date can continue to be 0 rated. Does it have to fall within one of these categories?
It can continue to be 0 rated. This is looking at those member states which haven't 0 rated or haven't applied the reduced rate. They can now do so. So this is opening more opportunities.
In 2006 or in 1992?
1992, which is after the
After the standstill.
So from 1992, those member states which had not previously zero rated newspapers.
Yes, if the second paragraph of 28. This is, my lady, when...
Let me just finish my thought.
Yes, of course.
So that they've not previously 0 rated newspapers, so they weren't able to take advantage of the earlier standstill provisions, but now they are so permitted.
Yes. I hope that's right. And the downside of appearing in a restricted court setting is I can't turn around to the officer and get a nod or a shake of the head, but I can look at the camera and hope that at least over the lunchtime adjournment I get...
Well, Mr. Peacock doesn't seem to think that's right. I mean, I'm not inviting submissions, but if you want to just tell us whether you do think it's right or not.
Well, my understanding, I will perhaps take the same opportunity to check, is that there were reduced rates permitted by the indent to the second directive. What is not made clear in 1967 as to whether there was any limit on the scope of that which could be reduced rated. So my learned friend is not quite right to suggest that the ability to reduce rates for newspapers, books, etc. Was first available to the member states in 1992.
Right, but he is right in saying that those member states which didn't benefit from the standstill provision based on what they had previously done could then 0 rate at some stage going forward because of a specific derogation permissible in the directives.
I'm not even sure without checking that that is right. Perhaps if I do some digging whilst I listen to that.
So what we're looking at, of course, is reduced rates, although there's reference to 0 rates in the text. The point I'm making is that Europe has been grappling with this problem for years, and that's relevant context to the operation of the always speaking principle.
That is the significance of what you're drawing our attention to in this legislative history.
Exactly.
The actual detail of the legislative history is not particularly relevant.
The reason for it, and whether it's confined to reduce rate or 0 rate, is not relevant for this overall submission. There are some provisions, 98.2, when we get to it in the Principal VAT Directive, which is clearer as to reduce rates. And the argument below from my learned friend is that this is not about reduced rates, this is about 0 rates. And we say the answer to that is they're both about exemptions. And that's the point I'm trying to make now.
Well, the question I'm trying to ask, I think, is that I had previously understood that the word newspapers, which we are construing in this case, was not there as the transposition of the word newspapers that appeared for the same purpose in an EU enactment.
Which is correct.
Right,
It
and
was
that's still
right. It was
still right.
always, as we get to the European,
it's a domestic. So there is reference to newspapers in the directives, but this reference in the legislation that we're construing is not the transposition of one of those.
the point I was making by showing you the list is the overlap between that list of items. And also, the other point is no reference or no need to have a specific reference to printed books or printed newspapers. The clear assumption as we go through the community law was that this was a reference to goods, to physical items. And this is relevant particularly when we get to non-printed books in the European case law, such as CDs, CD-ROMs. The other point that I'm moving on to is that European Parliament, European law, distinguishes goods such as books, newspapers, from electronic supplies. That's probably at the heart of the interpretative assistance one gets from European legislation. And you can see that as early as it's in the regulations consistently. Maybe the easiest way is to start with the 6th directive again. If you go to page 17, that's the first page of the Council Directive 2006.
So you're saying that's the earliest date you see the distinction between the supply of printed
I will
goods
check,
and
lady, it might be earlier, but
Might be.
certainly it was there by 2006. So what you get in 2006 is, and this is constant, the distinction between supplies of goods and supplies of services. So can I just make that good? Page 18, Article 14. Now we're into the principal VAT directive, so it's the same point. Supply of goods means the transfer of the right to dispose of tangible property as owner. And the rest of Article 14 follows. So that's the supply of goods. Supply of services has a separate article, and it's Article 24. Supply of services shall mean any transaction which does not constitute a supply of goods. And then there's a reference to telecommunications services. If you look at across the page, you'll see there's a separate heading, place of taxable transactions, page 19, place of supply of goods. And we haven't copied for you, but then you proceed on the basis that there is a separate set of provisions for place of supply of services. And an example is covered by Articles 43 to 59. The only example we thought useful is on page 20, supply of miscellaneous services. And Article 56 This is before a change which was made a decade later in 2016, but just this is the 2006 version. Supply of miscellaneous services, Article 56. The place of supply of the following services to customers established outside the community or to taxable persons established in the community, but not in the same country as the supplier, shall be the place where the customer has established his business or has a fixed establishment, for which the service is supplied, or in the absence of such a place, the place where he has his permanent address or usually resides. You can see the potential for litigation that those words cause, and they have over the years. And then there's a list, and the list at K is electronically supplied services, such as those referred to in Annex 2. Before I go to Annex Roman 2, on the next page you'll see Article 58. In order to avoid double taxation, non-taxation and distortion of competition, Member States may, with regard to the supply of the services referred to in Article 56(1, and with regard to the hiring out of means of transport, then A and B. However, this provision shall not apply to the services referred to in point K of Article 56(1, where those services are rendered to non-taxable persons. This is highly technical, not exciting stuff, but you can see already that electronically supplied services has a life of its own. And Article 63, just seeing it there without spending too much time, the chargeable event shall occur and the VAT shall become chargeable when the goods or the services are supplied. Before I go back to the earlier provisions, could you turn to page 28? Which is Annex 2, referred to in Article 56(1)(k). And you'll see there is an indicative list of the electronically supplied services. And you see website supply, web hosting, supply of software and updating thereof, and 3, supply of images, text and information and making available databases, which would cover product supplied by respondents. That description.
So just remind me when you started publishing, when they started publishing the Times Online?
It's 2010. I forgot the
2010.
date. I think that's the date we're looking at.
Well, different iterations were introduced at different points in time. So the very earliest online website edition was 1991 and 1992. But the tablet version came along in 2010. And so different iterations have had slightly different start dates. But for the purposes of this appeal and the original claims, one can think of them all being in place by 2010.
Thank you.
Could I'm sorry to jump around, but it's the only way I can make sense of this provisions. Could I just show you how that changes and then go back to the earlier provisions? So that's as at 2006. On the next page, you will see the Annex 3 provisions, which is a repeat of the list of supplies and goods and services to which the reduced rates may be applied. The reduced rates we'll see is Article 98. And 6 is a repeat of what you saw earlier. Supply including on loan by libraries and books, including brochures and leaflets and similar printed matter, children's newspapers and periodicals. So we say, again here, Europe is distinguishing electronically supplied services from this set of we submit goods. And this was the position until the very recent amendment in 2018. Could I just show you one other amendment and then we'll go back? The list of electronically supplied services was expanded in 2011, and that's on page 33.
So that's the list in Annex 2.
Exactly. And it was expanded by implementing
It was expanded in 2011.
11. It was expanded by regulations, and you can see those on page 30. This is Council implementing Regulation 282 of 2011, 15th of March 2011. And on the next page, page 31, you will see that Article 7 in the regulation lists electronically supplied services as referred to in the 2006 directive. Shall include services which are delivered over the internet or an electronic network, the nature of which renders their supply essentially automated, involving minimal human intervention and impossible to ensure in the absence of information technology. Paragraph 1 shall cover in particular, then 2a, the supply of digitized products generally, including software and changes to or upgrades of software. And then if you run your eye down to F, the services listed in Annex 1. Annex 1 is on page 33.
So the significance of this is that what is supplied here is, under EU law at this point, an electronically supplied service, as opposed to a good.
And different from.
And different from a good.
And different from in terms of one relevant point in particular, which is place of supply. By 2011, with this debate which has been going on throughout the Union, what do you do about the e-revolution? There are now e-versions, electronic versions of books, potentially of maps, periodicals, etc. So by 2011, Article 7, Annex 1, which is on page 33, expands at 3, point 3 of Annex 2, and again, I do apologise for the detail of all of this. I didn't write it. Point 3 of Annex 2 to Directive 2006/112 at C, the digitised content of books and other electronic publications. So we're now bang on point. Subscriptions to online newspapers and journals. Weblogs and website statistics, but then online news, traffic information and weather reports. And all of these three, C, D and F, are covered by News Corp's offering, particularly, of course, C and D.
So those are brought in by F in paragraph 2 of Article 7.
Yes. So that was a jump from Article, Annex 2 on page 28, and what I was showing is the contrast between the language used there and the language used in relation to books. Now, could we go back to the text of the Principal VAT Directive?
Well, Article 7 makes it clear, doesn't it, in paragraph 3, that it doesn't cover printed matter such as books, newsletters, newspapers.
Yes, so I should have, of course, emphasised that. It does not cover it. And when we go back, the reason I was taking you down this route is all because of Article 56, which deals with place of supply of miscellaneous services, and Article 58. 56 in time has changed its number, but I don't think that matters. Then we get to, eventually getting closer to Article 110, we get to page 22, which is Article 96, which is the updated version of Article 12.3 that was referred to earlier. Member states shall apply a
Sorry. Could you
Page
just
22.
flesh that? Yeah, right. So which directive are we in now?
We're still in the principle that we moved in there on page 17.
So Article 96 is the principal VAT directive.
Yes. And on page 22 is the standard rate. Article 96, Member States shall apply a standard rate of VAT which shall be fixed by each Member State as a percentage of the taxable amount and which shall be the same for the supply of goods and for the supply of services. Article 97, period doesn't matter, but it's a specific rate, not less than 15%. Reduced rates. Member States may apply either one or two reduced rates. The reduced rates shall apply only to supplies of goods or services in the categories set out in Annex 3. And then this important sentence, the reduced rates shall not apply to the services referred to in point K of Article 56.1, which, as we now know, eventually expanded to include, then referred to, electronically supplied services. We're not in reduced rate territory, we're in zero rate territory, but the underlying principle, we say, is the same.
But if you only charge a reduced rate output tax, can you still deduct all the input tax that you?
I wish that was a question you hadn't asked me. I'm not sure. I think the answer should be yes, but that's the magic of zero rating.
Yes, that's why zero rating is so favourable.
But I'm assuming it's the same, but you have charged, and it's a minimum of 5% at that time. See Article 99.
I think it makes no difference to your ability to recover VAT on expenses.
I don't think it does. I say that's the particular attraction of the zero rate. It's an exemption from the standard rate. It's lower than the reduced rate, but you can still get back your input tax. If I can go now to Article 110, 109 goes into it. Article 110 is on page 24. And this is where we get this 1st of January date. Article 110. Member States which at 1st of January 1991 were granting exemptions with deductibility of the VAT paid. So that's zero rate. And the important word, or. So this covers both. So if we're granting exemptions with deductibility of the VAT paid or proceeding stage, so at the proceeding stage, or applying reduced rates lower than the minimum laid down in Article 99, which is 5%, may continue to grant those exemptions or apply those reduced rates. There's the standstill date, and it's those exemptions. So it's the exemptions as listed. The exemptions and reduced rates referred to in the first paragraph, so that's both zero rates and reduced rates, must be in accordance with community law. That's how my learned friend brings in fiscal neutrality. We say it also brings in legal certainty and the persuasive decisions dealing with reduced rates when looking at zero rates. must have been adopted for clearly defined social reasons, not an issue in this case, and for the benefit of the final consumer. And 111.
So what happens to member states who weren't member states at the 1st of January 1991?
They have to make their own separate arrangements with the European Union when they join to see if they can join on similar favourable terms or not. And you can see an example as we get to Article 111, dealing with Sweden and Finland, which is dealing with the time between 1975 and 1991. I've assumed that there are similar provisions for between 1991 and now.
Right.
So Article 111, the next article, subject to the conditions laid down in the second paragraph of Article 110, in accordance with community law, clearly defined social reasons, etc. Exemptions with deductibility of the VAT paid at the preceding stage, 0 rate, may continue to be granted in the following cases: by Finland, in respect of the supply of newspapers and periodicals sold by subscription, and the printing of publications distributed to the members of corporations for the public good, and then of particular importance by Sweden, which I think joined around 1975, in respect of the supply of newspapers, including audio and cassette newspapers for the visually impaired, pharmaceutical products supplied in hospitals or on prescription, and the production of or related services concerning periodicals of non-profit-making organisations. So this example is interesting because it's an express exemption, an express difference from the other provisions. And the UK doesn't have that permission. It does have a similar permission for talking books, which I will show you in a few minutes. So what we get from these articles is a distinction between electronically supplied services, between books and newspapers and periodicals. And that is the same, doesn't change until 2009, relevant to these submissions, when there was a change to deal with technological developments. What was happening, as we all know, is that you could buy a book on a cassette and listen to it, or you could buy a book on a CD-ROM and watch it, read it on your computer screen. So in 2009, there was a council directive which amends the reference to books. This is on page 35. Three recitals not relevant, the fourth recital at the foot of the page. Directive 2006-12 EC should furthermore be amended in order to allow for the application of reduced rates or an exemption respectively in a limited number of specific situations, social or health reasons, and in order to clarify and update in technical progress the reference to books in this Annex 3. That's how we get to the change, and the change is on page 38. And there you will see that point 6 in the page you were looking at earlier is replaced by very similar language, except with the addition of these words: on all physical means of support. So it now reads: supply, including on loan by libraries of books, on all physical means of support. And then it continues as before. And what's happening there is another extension.
So
Okay.
on all, I'm so sorry, on all physical means of support, it extends to electronic means of support?
No,
No.
it doesn't, and we'll see in the case law.
Right.
So the first extension,
What
is this the one you see now?
But what does all physical means of support mean?
CD-ROMs,
CD-ROMs.
other physical objects,
So
other,
audio
other
cassette.
goods.
Oh, I see.
And we'll see that that's why they had to change again.
Tapes.
Tapes, yes, possibly. And this is not speaking of talking books, of audible books. It's talking of the images that you can access from something physical rather than paper.
So a floppy disk. Or
Floppy disk is the other example used in the case law. And then we get to, they had to, and that wasn't enough to bring in electronic supplies. That's the important word. So you've got an extension and then another extension, whereas in the UK you don't need to do it according to the Upper Tribunal. You just refer to the always speaking principle. So 2018 is the change, and that's on page 40. This is Council Directive 2018-1713, amending Directive 2006-112 as regard rates of value-added tax applied to books, newspapers and periodicals. We're now right in the detail. And this follows from a proposal. You'll see the second line, having regard to the treaty, but then having regard to the proposal from the European Commission. The proposal is on page 641 of this bundle. And could I invite you at some stage to read it? It sets out the Commission's views, which become the legislation. And that was preceded by a consultation Europe-wide, which is at page 637. That was, I think, April 2016. And
Sorry,
this-
what was the page number again?
Page 637.
Thank you.
And of course, not determinative, and not even perhaps as high as authority, but the position of the Commission is one of the UK's concerns about infraction proceedings is on page 638. This is what the Commission was saying as a public consultation. Member States have the options to tax printed books, newspapers and publications at a reduced rate, minimum 5%, and some members were granted the applications of VAT rates lower than 5%, super reduced rates, including exemptions with a deductions right of VAT at the preceding stage, so-called zero rates, to certain printed publications. On the other hand, digital publications that are electronically supplied have to be taxed at the standard rate. So that was there. So the importance of the directive is in 2018, why did this change? And if you could...
But I mean, this is not completely insignificant, is it? That this was the purpose of the legislation.
No.
I mean, this
You say it's at the
is
heart
it.
of
Is it? Can you go so far as to say that this was the received wisdom under European law
Yes.
as at 2018?
Yes, I can say that this debate has been continuing for years with expressions of judicial concern that there will be fiscal neutrality issues unless something is done about the emergence of digital services, particularly in relation to books. and they've been around a long time, e-books. And
E-books.
that's short for electronic.
And they've been around for a long time, being how long? I mean, it's difficult because these things merge in one's memory. You know, we now think...
I have to be careful. I don't want to... My own friend will jump up and stop me, but I did enough research to find by my main source of Wikipedia. 1949, I think, is the first one. But widely
Well, not on the internet in 1949.
No, of course not. You could then see a digital version on the computer.
I see.
The first versions that we're familiar with is Kindle and the like that you can download from the British Library free without paying your Kindle rates.
Yeah, okay, that wasn't really what I meant, but yeah. Okay. I mean, that sort of history probably won't help, but you say it's been going on a long time, this debate.
The important point is that this debate has been going on in Europe at the same time as for some years, and you can see it in the recitals.
Mm.
You can see it in the judicial concern, which is referred to not always in recitals, but here is expressly referred to.
And it is part of the problem, the difficulty of identifying the place of supply, if that is, well, I was going to say if that is not the place of the customer, because where it's actually being supplied from is a very difficult question with all electronic
Yes,
services.
and it
Is
brings
it some desert in Nevada, or is it Wapping, or
exactly so. And it's referred to here. It's as a reason.
As a reason for the
Change.
For the change.
The concern, take the example of buying the Times. You go into your newspaper, you give them your £2.50, whatever it is, and you get a product, good, and you know where you bought it, who sold it. And there will be a chain whereby that good gets into the newsagent or the supermarket, and there will be VAT. There would be VAT along the line if it was chargeable, but it's zero rate. If I could just read the recitals, that may be the shorthand way of dealing with this. So there are
Where are we
Which
going
is-
now?
page 40.
Page 40.
This is the 2018 directive. In the proposal for a directive, the EU Commission had said this, that the VAT directive prevents member states from applying the same VAT rates to e-publications as they currently apply to physical publications. That's page 642. I won't take you to it. Now look at the recital.
Sorry, where are you reading?
That was to save you going to page 642, which is the proposal referred to at the top of this
Yeah.
directive.
And we've looked at the consultation and now we're back in the directive.
The recital. Council Directive 2006 provides that member states may apply reduced rates of value added, etc. However, a reduced VAT rate cannot be applied to electronically supplied publications which have to be taxed at the standard rate. In line with the communication of the Commission in 6th of May 2015 on a digital single market strategy for Europe, and in order to keep abreast of technological progress in the digital economy, member states should be enabled to align VAT rates for electronically supplied publications with lower VAT rates for publications that are supplied on physical means of supply. And then it's these two. In its communication of 7th of April 2016 on an action plan on VAT, the Commission outlined that electronically supplied publications should be able to benefit from the same preferential VAT rate treatment as publications that are supplied on physical means of support. In its recent judgment in case 390/15, and you can go to the footnote, and that is the RPO case, which is in this bundle at page 233 for the court and 211 for the Advocate General. In this recent case, the Court of Justice considered that the supply of digital publications on physical means of support and the supply of digital publications electronically amount to comparable situations. Therefore, it is appropriate to introduce the possibility for all member states to apply a reduced VAT rate to the supply of books, newspapers and periodicals. It is appropriate to allow those member states that, in accordance with union law, currently apply VAT rates lower than the minimum paid laid down in Article 99, or that grant exemptions with deductibility of the VAT paid at the preceding stage. So this is covering both reduced rates and zero rates, and it's both in accordance with union law. To certain books, newspapers or periodicals supplied on physical means of support, to apply the same VAT treatment to such books, newspapers and periodicals when supplied electronically. That's the proposal, now the power. And the fourth recital. Since the 1st of January 2015, VAT on all electronically supplied services has been levied in the member state where the customer is based. Given the implementation of the destination-based principle, it's no longer necessary to apply the standard rate to electronically supplied publications in order to ensure the establishment and the functioning of the internal market and to avoid distortion of competition. So there's and 5 to complete it. In order to prevent the extensive use of reduced rates on audio-visual content, then there's the exclusion of musical video content. Over page 6, member states should maintain...
What I get from recital 4 is that they had to sort out where the place of supply is and switch it to be the destination rather than from where it comes before they could make this change.
Yes, and that place of supply rule, unless I'm wrong, applied in the UK.
Yeah.
All of this is to show that there was a reason, and that would be a reason, of course, for addressing fiscal neutrality. There was a reason for having different treatment for physical books from books that are supplied remotely, digital versions. Over the page, you'll see the amendments. Well, 6, I should have read. Member states should maintain discretion to set VAT rates for publications and restrict the scope of reduced VAT rates, including subject to objective justification, where digital publications offer the same reading content. And you'll see, since the objective of this directive is 7, namely enabling member states to apply the same VAT rates to electronically supplied publications as the VAT rates they currently apply to publications on any physical means of support, cannot be sufficiently achieved by the member states. It can be better achieved at a union level. The union may adopt measures in accordance with the principle of subsidiarity, etc. And then the paragraphs are added to Article 99 that you saw earlier. By way of derogation from paragraphs 1 and 2 of this article, and in addition to the rates referred to in paragraph 1 of Article 98, member states which on the 1st of January 2017 applied in accordance with union law reduce rates lower than the minimum laid down in this article are granted exemptions with deductibility of the VAT paid at the preceding stage, 0 rate, the supply of certain goods referred to in point 6 of Article of Annex 3 may also apply the same VAT treatment when that supply is supplied electronically. And then there's the amendment to point 6 in Annex 2. So instead of physical
Annex
means
3.
of support, it now adds either on physical means of support or supplied electronically. And it's been rearranged so it reads books, newspapers and periodicals, which otherwise would be printed goods, now either on physical means of support or by electronic.
But it's still, I mean, it still assumes that it's a newspaper, doesn't it? The definition. It assumes that it's a newspaper, but now it's a newspaper not on physical means, but supplied electronic.
Yes, so the understanding of newspaper by this time, Europe and books, is focusing more on content. And the UK has followed that lead, that permission. The point is of course obvious, that alone amongst the member states, the UK didn't need to wait for this permission according to the Upper Tribunal. The UK not only had the ability to charge.
Well, do we know that? Do we know that none of the other member states, Finland or Sweden or anybody else, that they've all, their courts have decided that...
No, we don't know of any other member states, so the only member state we know of is the UK, put it that way.
Right.
Sorry, I don't understand. You mean do you mean that you don't know of any other member states that have made a similar decision to the Upper Tribunal, or do you mean that you have no idea what has happened in other member states?
I think I will backtrack and stick with the no idea.
Well, I mean, that's if I may say so, rather surprising. I mean, surely if there were decisions in other member states, they would have been available to you.
At member state level rather than at European level.
Well, I mean, if there were decisions of courts in the other member states deciding something similar to the Upper Tribunal, one would know about it. Well, one could know about it.
Well, Lord, I don't.
But you don't.
I will,
Right.
again, those sitting behind me can check.
All
Well,
right.
that's right. I don't know. But we don't really know whether the UK is alone in extending its standstill to...
Before this permission. After, of course, yes, they can.
Yeah.
No, I mean, we're talking about two different things, and we have to keep them
Yeah.
completely separate. The first thing is whether any other member state's court has decided that the zero rating applicable to printed newspapers also applied to digitally produced newspapers before 2018 directive. The second question is whether, pursuant to the liberality allowed in the 2018 directive, other member states have allowed zero rating for digital newspapers, and I'm sure that that's very likely that they have.
Yes, it's the second one that is of.
Sorry, I can't hear you.
I'm sorry. The second one is, I thought, it doesn't matter whether they have or not.
No.
What we know is that the UK now has. So, and it's mentioned by my learned friend in his skeleton argument. Our skeleton argument was prepared very shortly before the change in the UK, and it would have been today that it came into force, 1st of December, but because of COVID-19, the change was brought into force on the 1st of May.
On the 1st of
May.
That's the coronavirus
I'll show you that as we run through.
regulation.
My Lord, I apologise for the last submission, which really was unnecessary to look at other member states, but if, insofar as there has been litigation...
Well, I mean, it would be of significance if there were other member states which had taken the same view of European law as the Upper Tribunal. That would be of significance. Potentially. I mean, it depends what they said and what the legislation was in those member states, but I mean, it would be potentially of interest. And
all I have is, or we have, and all this court has, is the European level.
Yeah.
Yes, yes. No, I understand. I mean, I understand, and I understand if you don't know the answer. It's a confusion, which is why you apologise for the submission. But I'm just saying that if those behind you or behind Mr. Peacock are able to find out whether there has been any such litigation or authority in other member states, it might be of interest to look at it.
What we can see, Lord, is that in some other member states, this has been a referable point. And so the member states have referred this question, can they zero rate e-books? And that's what we find in RPO, which is referred to in the directive. So, but I will, those sitting behind me hear what you say, my Lord, and I will do what I can. So all I know is the route to the European courts.
Mm.
So could I then turn at much more speed to the domestic position, because that hasn't changed. Domestic legislation starts on page 42. You don't see in the domestic legislation reference to the clearly defined social purpose, social reasons that you find in the text of Article 110 and its predecessor. The underlying purpose of the zero rating of books and newspapers was not controversial before the FTT or the Upper Tribunal. And it's, if I give you the references without going to it, in the FTT it's paragraph 17 at page 134. And in the Upper Tribunal it was paragraph 40, which is to like effect on page 95. To promote literacy, the dissemination of knowledge and democratic accountability by having informed public debate. In 1972,
You do that by keeping the price down,
yes,
by not having to add 5% or 20% more,
exactly.
make it more affordable for people.
The same for children's clothing, the same for other items. And there are two categories. There's reduced rates, and then there's a zero rate, and it's confined food for public consumption. It's effectively the list of items, goods and services which were excluded from purchase tax. So that's where it comes from. You can see in paragraph 17 of the First Tier Tribunal, there's reference to evidence that was before that tribunal of what was said in 1972 by the then minister. So it's common ground. If we can just see how it appears, how we get to current provision, Finance Act 1972, effective from when we joined the community on the 1st of January 1973. Section 12, zero rating. Where a taxable person supplies goods or services and the supply is zero rated, then whether or not tax will be chargeable on the supply apart from this section, no tax shall be charged on the supply, but it shall in all other respects be treated as a taxable supply, and accordingly the rate at which tax is treated as a charge on the supply shall be nil. So that's you get back all your other VAT. The supply of goods or services is zero rated by virtue of this subsection. Goods or services are of description for the time being specified in Schedule 4, or the suppliers of description for the time being so specified. We say there's no significance in the fact that this is a reference to goods or services. The same language as appears in section 31, but it seemed to be of some significance to the Upper Tribunal. Zero rating is on page 44. This is as at 1972. And the first item is food. The reason that food is relevant is when you look at the fiscal neutrality case law, particularly the sub 1 case, because you'll see that unusually with food you have not only an item, but you have exceptions. So the item under general items is, start again, supply of anything comprising the general item set out below, except a supply in the course of catering, and a supply of anything comprised in any of the accepted items set out below, unless it is also comprised in any of the items overriding the exception set out below, which relates to that accepted item. You can see the recipe for litigation in those items.
And there's been much of it.
The annex to sub 1 in the Court of Appeal has a list of cases which flow from Group 1. And what you see are general items, assumption, and then accepted items, including ice creams, ice lollies, frozen yogurt, and then you get items overriding the exception. So the difference between chocolate, sweets, and similar confection is overridden by chocolate confiture not prepared or put up for retail sale, and drained cherries. When we get to books, which is our much more simple set on the next page, and this hasn't changed. Group 3, books, etc. Item, books, booklets, brochures, pamphlets and leaflets, newspapers, journals and periodicals, children's picture books and painting books, music, printed, duplicated or manuscript, maps, charts and topographical plans, covers, cases and other articles supplied with items 1 to 5 and not separately accounted for. Obviously all goods, certainly as in 1972, and by their description we say all goods, and that's confirmed by 6. So it covers, cases and other articles supplied with items 1 to 5. There were no notes at the time, but there was another group, and that's talking books for the blind.
There is a note.
Oh, sorry, one.
Plans or drawings.
Yes, sorry, one there. I'm sorry, my learned friend reminded me, because we have we'll come to the other notes when they're numbered.
Right.
This group does not include plans or drawings for industrial, architectural, engineering, commercial or similar purposes. The point more important point is talking books for the blind is a separate category. The supply to the Royal National Institute for the Blind of a magnetic tape specially adapted for the recording and reproduction of speech for the blind, tape recorders designed for the reproduction of sound from such tape, parts and accessories for goods comprised in A and B, and then there's a difference between newspapers and newspaper advertisements and news services. So that's how it was in 1972. If I could just pause at page 48, another one that comes up in the European case law, and that's caravans. Caravans is group 11. Caravans exceeding the limits of size for the time being permitted for the use of trailers on the roads. This item does not include removable contents other than goods of the kind mentioned in item 3 of group 8. So that's one with an exclusion. Then we get, without troubling you with the 1983 Act, we get to the current Act, and this is on page 49, the VAT Act 1994. Zero rating is in section 30. It's in the same language as in 1972. It's again supply of goods or services, and it's now Schedule 8, otherwise no change. And Schedule is on page 52. Which deals with, sorry, Schedule 8 is on page 53. Schedule 4 deals with the definition of goods and services, which is on page 52. It's so similar to European language that I won't read it, save to show you that it involves the transfer of the whole property in goods as a supply of goods. So when we get to Group 8, Schedule 8, sorry, this is as printed, it looks as printed for this hearing. It's on page 53. rather than going through all the others, food, children's clothing, etc., you just have books. It's exactly the same. Nothing has changed. The draftsman hasn't added anything else. What has changed is there are different notes. So if you get to page 54, there's now an additional note, and indeed a further note was added. The reason I refer to notes at all is the addition of notes became the subject of some submissions in the First Tier Tax Tribunal. A learned friend's submission was that if you look at the notes, it will assist you in understanding that there are services in the items. And our counter submission was, no, that's wrong. The notes are all consistent with what you find in items 1 to 5 are goods. And just by way of example, you can see note B, which was added in 1977. There were later notes added. Include the supply of the services described in paragraph 1 of Schedule 4 in respect of goods comprised of the items. So the services is linked only to the goods. And we say, as a matter of construction, without now looking at always speaking, that the list in group 3 is all goods. Talking books is expanded, but it's still different from what you find. The latest version is 2011, which is on page 55. Perhaps this is the one to work for. This has the same
Which page?
language.
85.
It's 55 and then 56.
55.
Here you have all the items. An issue before the Upper Tribunal is whether or not the notes which came after 1972 can change the meaning of the
So
separation.
what's the difference between 53 and 55?
The addition of an extra note. That's all. On 50,
No, I know, but what's... they're both the 1994 Act, but what's the difference in
the page
time of
54
application?
is, although it gets generated as at October this year, it's as at, I think, 1997. It's earlier.
Right.
Sorry,
Well, it
which
says-
date? 97.
I think it's, I'll make sure you get the right date.
Well, I mean, the one on page 53 says at the top of the page that it's as at, I thought it said 2010.
No, I
That's
think it's the, what you see is the
That's
first
just the
of April
printout, isn't it?
2010. You just see those, it isn't 07, it's 2010.
Status, point in time view as at 1st of April 2010.
Oh, so that is 2010. Oh, not
2010.
97.
Whereas the one on page 56 is at 2011, because the extra note was added in 2011.
I see.
The submission we make and repeat is looking at the notes in 1972 or in 2010 or 2011. There's nothing in there to suggest that anything in the list of items is other than goods. And indeed, if anything, the notes are consistent with the draftsman in 2010 and 2011 proceeding on the basis that they are all goods.
But I mean, why, when you're dealing with Article 110, which says that member states which, as at 1991, were granting exemptions, may continue to grant those exemptions, aren't you looking at what the exemption was all that time ago?
Yes,
And the always speaking principle may well apply to that period, but it must apply to that period if it's going to operate.
That's what we say the effect of the standstill is. The reason there were in notes at all was a submission that this somehow supports my other friend's then main submission, that without always speaking, the parliamentary intention was to include services. We say,
But I mean, even, yeah.
The fact that these notes were incorporated in 2010 and 2011, they could only have been incorporated if someone had taken the view that that was what had been meant by the words in at least 1991, isn't it? Because there was no liberalisation of the ability to zero rate things until 2018.
yes, there was no, we say the proper legal analysis in European terms is the effect of Article 110 is it needed a further permission from Europe to extend the scope.
Yeah, but insofar as these notes extended the scope of Group 3 in 2010 and 2011, that could only have been on the basis that that had been the scope as at 1991.
In other words, didn't extend the scope,
Didn't
just articulated the
Articulate,
existing
exactly.
scope.
Exactly.
with one small caveat, you can remove an item
Yes.
and you can say that the item does not include, for example.
Yes.
And that's what at least two of the notes were saying. It doesn't include plans or drawings for industrial and architectural. So you can add that at any time. Because you wouldn't be...
Right, but this addition of the supply of services connected with, in note 3, that, as my lady says, must be taken to be an articulation of what had already been zero rated as at 1991, because there was no power to add anything.
Yes, and it's still all goods is being talked about. But with the addition of services for the purpose of the goods in 5,
Yeah.
1 to 4. Sorry, 1 to 4.
Well, it's what it says.
Yes.
It is the supply of goods connected with the supply of services.
But it's still, there's nothing in the language of these notes to lead to the conclusion that items 1 to 5 are anything other than goods.
I'm afraid I can't remember what paragraph 1.1 of Schedule 4 was in Note 1B.
That's on page 52. That's lending, isn't it?
It's lending.
As lending, yes, thanks. That's what I want.
This is dealing with libraries, and where you
Yeah, yeah. No, it's okay. Okay, I remember now. I just
There's
forgot.
no transfer of the right. And we say that the notes themselves, if this ever arose, must be interpreted on the basis that they do not extend the list of goods because they would be Europe impermissible. So the domestic legislation it just takes a couple of pages, really. It hasn't changed much over the years.
But the amendment that is made then on page 57, as at May this year, to implement or to take advantage of the 2018 directive is made expanding Group 3.
Exactly. So there's a new item 7, and that's permissible because our section 30 allows both goods and services to appear in the list.
So they were all goods, but now they've become goods and services.
And they become goods and services by statutory addition and by European permission.
Hmm.
And it's limited to the first three items. So it doesn't deal with music. Or
Well, the sixth item you can't supply an electronic case. Well, you can, but not in this context.
No, 4 and 5 aren't included.
No, I understand, but 4 and 5 it doesn't apply to music and doesn't apply to maps, but it also couldn't apply to 6 anyway.
Maps is potentially interesting because of satellite navigation. Leave that for another day. But that's not included in this list of expanded.
No.
So the publications listed in 1 to 3 when supplied electronically, but excluding publications which are wholly or predominantly devoted to advertising, etc. And there's nothing really.
But it covers the 3 most economically significant, I would have thought.
Yes. And
That promote literacy.
It has the same same authorization under Article 110 of literacy, information, access to knowledge in a democratic society.
When something is 0 rated, is it 0 rated throughout the whole chain of distribution of goods?
No, just at the retail.
Well, so how does that work then? So when the newspaper publisher sells the goods to the newsagent or to...
Oh, sorry, yes, sorry. I think there's no, again, I assume that there's no VAT in the, I'll say nothing.
Well, it's 0 rated at every supply of that good.
Yes.
So if it is a good supplied by a wholesaler to a retailer, who are both, it would be 0 rated at that point.
I thought it was only to consumers.
No, it's the interest of consumers is the requirement of the second paragraph of Article 110. Must be for the benefit of consumers.
Yes, but that's not interpreted as meaning it has to be, it's only the supply to the non-taxable person.
When it becomes a book and it's supplied down the chain, as I understand it, corrected and will correct, all of those supplies are 0.
Right, okay.
Yeah.
But insofar as expense has been incurred along that chain with value being added or however it's worked out,
Input tax on things that are not the actual item
then you
can
can
be deducted from the...
production of the book. It's the best, easiest example.
No, but I mean, if you imagine the creation of a newspaper, the purchase by News Corp of rolls of paper would not necessarily be 0 rated. Once they had turned them into newspapers by printing material on them and selling them to a newspaper wholesaler, they would be newspapers, and therefore, I'm assuming, and once they were then sold from wholesaler to retailer, they would be newspapers and 0 rated, and once they were sold by retailers to individuals, they would be. But before they became newspapers, they obviously wouldn't be, or it would depend upon what was being sold.
And all the supplies that were necessary to make that good is VAT deductible. And the various forms of supply are really almost endless, but set out in that guidance from Her Majesty's Revenue Commissioners at the end of the bundle.
No, but it slightly makes good your point about the difference between goods and services, because a service doesn't have a chain like that. It doesn't have a supply. It's not created in the same way as a good is created.
Yes, I focused the submission. It's a broad submission. There's a difference between goods and services. But then the more specific one, which finds manifestation in recital 4 or 5 in the 2018 directive, and throughout the consultation period, is that there was a particular problem for subscriptions to online newspapers, books, because of the place of supply and where you tax. So there was a loss of the tax because of the reference to a desert in Nevada or wherever it came from.
Yeah, but what I'm really talking about is the sort of licensing arrangement. I think you said right at the outset that you don't actually gain anything in the service you buy except the right to look at it. You can't sell it on. You don't have anything. You don't have any property in the service in the newspaper that you get online. You're allowed to look at it, and in fact, if I remember rightly, there are conditions as to how many devices you may look at it on with one subscription.
And you can, by permission, if you click the little arrow in the bottom right-hand corner, you can send the entertaining cartoon to somebody, but also electronically.
You can, but that's part of the terms of the license on which you buy the service.
But you don't pass it on because you own it.
No.
You pass it on by permission.
I mean, it's a completely different concept. I don't think this was the submission you made right at the outset, that it's a completely different process and concept to apply VAT to services than to apply them to goods, even though they are grouped together in the legislation.
While we're still on the domestic legislation, the submission which found favour with the Upper Tribunal is the person back in 1972 didn't specifically exclude anything. It's just a list of goods, list of items. We have been troubled by that conclusion that there is no exclusion. And the interpretive could perhaps be addressed as follows, that any sensible reading of the 1972 legislation is that the draftsperson assumed and therefore did not need to include the word printed for the other items. And
He needed to do it for music,
exactly.
but he didn't need to do it for anything else.
And the reason he didn't need to do it for music is the assumption was that it was already there. The point taken against the Commission's by Malone and Friends and accepted by the is that somehow the music reference assists the argument for the respondents, for the News UK. But with great respect to the Upper Tribunal, it's quite the opposite. The fact that you need to put the word printed by reference to music is you could get music at a performance, which you could pay for, without it being printed. Whereas a book, a newspaper, periodical, and it's of relevance that a newspaper appears with these reference to journals, periodicals, are all printed goods, assumed to be printed goods, and should be read as if that word appears in the legislation for common sense reading.
So you say when they're in relation to the one item where there was a non-print alternative, they did exclude that non-print alternative.
Exactly. We've mentioned this in our skeleton argument at paragraph 37 and in paragraph 21. So the counter argument is, this is in paragraph 37.2 of their skeleton argument. It may be worth just turning it up. I think that's where he deals with, when deal with music. Yes, it's 37.2 on page Core Bundle 63. The FTT wrongly concluded, and this is picking up the Upper Tribunal's reasoning, the FTT wrongly concluded that item 4 was limited to goods, and that in any event this had some bearing on the scope of item 2. However, if the words in brackets after music, which stated printed, duplicated or manuscript, restricted item 4 to goods only, the absence of such words in item 2 will imply that no such restriction applies to it. In other words, Parliament could easily have restricted newspapers to printed ones only, but did not. And you can see this continued in paragraph 39. And it's back to music. The self-evident reason why the word printed was necessary was to exclude this very large further set of taxable supplies for which the same social policy justification for zero rating did not arise. Not really clear why it didn't arise, but talking with great respect to my learned friend and to the Upper Tribunal, that is wrong.
But even with music, it was still, at that stage, a physical good. It was a record or a...
You could have a live performance, which you pay for. Still, would you be paying for the service of the musicians, which you could be said to be buying music. But we say it's blindingly obvious. It's all printed, it's all physical goods, and that was the parliamentary intention at the time. And that becomes relevant when we get to the always speaking argument. And it may be that one can stand back a little bit, and if the word printed had appeared, we wouldn't be here today, because it seems to be accepted that that would amount to an exclusion, or somehow would block the development of the argument. Learned friend can perhaps go further.
You say there wasn't anything that was not a printed newspaper in at the relevant time.
And probably not in 91. So we're concerned with the language of the draftsman in 1972. And what's happened now, in Europe, the gap has been filled with legislation, and now in the UK with the addition of item 7. But the Upper Tribunal has filled the gap with the always speaking argument. That's impermissible. Or not, you will tell.
That's why we're here. Yep.
Well, you've seen all the language. I've been making submissions inevitably as we go along. Could I just take them very shortly? EU law distinguishes supplies of services from supplies of goods. We've seen that repeatedly. The supply of electronic books could not be regarded as a supply of goods, since an electric book could not be regarded as tangible property. That's a quote. I give you the reference without taking you to it. That's from the European Court of Justice in Commission against Luxembourg. It's in your bundle at paragraph 42. Page 200, and appears in the head note and in the judgment at 221 and 207, I think, is the Advocate General and the Court. So if I could, maybe it'd be quicker just to take you to 200 is the first page. And you can see if you just cast an eye over the head note where this appears. It's just over the page at 201. Supply of electronic books could not be regarded as a supply of goods, since an electronic book could not be regarded as tangible property. The physical support enabling an electric book to be read, which could qualify as tangible property, was not part of the supply. in the text on page 202, you'll see the legal context. And on page 203, you can see the evolution of Annex 3 in paragraphs 11, 12, 13, and 14 with reference to electronic supplied services. And that passage appears again at 207, which is...
This was dealing with of point 6 of Annex 3.
Yes. It's again that statement which we say you can read across. Whilst you're on this case, it may save coming back to it. The paragraphs I invite the court to read are 33 through to 51. And you'll see there the language of exceptions and extending the scope, and also a reference to interpretation on a strict basis. And I say I won't read it all, but paragraph 51 is the reference to fiscal neutrality. The principle of fiscal neutrality cannot extend the scope of reduced rates of VAT to the supply of electronic books. It cannot extend the physical to the electronic. Point 6 of Annex 3 is not a provision which unequivocally extends the scope of reduced rates of VAT to the supply of electronic books. We say the same reasoning, though that's reduced rates, applies to zero rates. So the third point from all of this context is electronically supplied services has been singled out a form of services, both in the EU and the UK. And you've seen the reference to the importance of place of supply. One other reference which confirms that digital books falls within electronic services, and that's in the RPO decision at paragraph 57. The reference is page 233 and page 242 to 243. To use the language of the case law we're getting to, which is the Lord Wilberforce's dissent, it's different in kind.
Give me those page references.
It starts at page 233, and the relevant paragraph 57 is at 242 and 243. And the same phrase, electronically supplied services, also appears in the domestic legislation, but we haven't troubled you with the provisions. And finally, in order to extend the meaning of books in light of technical progress, it was necessary to add, first of all, wording on all physical means of support, and then later by reference to digital supply. The relevant case law is, again without taking you to it, is the case of K. Oy, O-Y, and it's in the authorities at page 182. Paragraph 12. That sets out the evolution of the provision, but also describes the physical means of support as CDs, CD-ROMs, or USB keys. Just list. And in the same case, in K. Oi, at page 198, paragraph 27, the addition of the words on all physical means of support was itself an extension. And the final reference is in the RPO case that I mentioned earlier, and it's the Advocate General in RPO at paragraphs 1, 25 and 28, and its authorities pages 214 to 215. He there refers to extending the scope. And bringing all this together, if adding on all physical means of support, or talking books, or radio and cassette newspapers, or of the scope of a permitted reduced rate of goods and services, it must logically follow that adding the supply of electronic digital services to a list of goods is also a clear extension of the category of zero-rated items and would offend Article 110. That submission was rejected by the Upper Tribunal at paragraph 51. So that's the legislation and many of our submissions set out. Could I now make one or two general submissions on the always speaking principle, unless there are any questions on the legislation framework that I've been taking?
No, thank you.
Yes, I'm sorry, I should have made this clear. This is a Billy Do from a learned friend. I should have emphasised that the 2018 change applies only to member states who already zero rate, for example, printed newspapers. And that deals with the fiscal neutrality. So, I apologise for not mentioning that. So on the always speaking principle, a principle we're all familiar with, brought up on it. We don't seek to challenge the description of the principle in Bennion or by Lord Bingham in Quinterville. And the reference for Quinterville is in the Upper Tribunal at paragraph 43, but in the authorities at page 430 and page 435. Might be worth just looking at Lord Steyne in the same case, page 441. This is dealing with the definition of live human embryo. So Lord Bingham's speech begins on page 432 of the bundle. The main paragraph is paragraph 8 on page 435. And it ends, the court's task within the permissible bounds of interpretation is to give effect to Parliament's purpose. So the controversial provisions should be read in the context of the statute as a whole, and the statute as a whole should be read in the historical context which led to its enactment. At page 436 we get the now very well known dissenting passages from Lord Wilberforce in the Royal College of Nursing, which is now to be treated as authoritative. And we rely strongly on this passage, not just for the reference to restrictive or circumscribed its operation, rather than liberal or permissive. Reference also between E and F to different in kind or dimension. And then this, in any event, there is one course which the courts cannot take under the law of this country. They cannot fill gaps. They cannot, by asking the question, what would Parliament have done in this current case, not being one in contemplation, if the facts have been before it, attempt themselves to supply the answer. The answer is not to be found in the terms of the Act. Lord Staines's speech begins on page 439. And if you could just see paragraph 22 is a useful summary of case law and the avoidance of absurd consequences. And 25, after further examples. And just above 25, the analysis of Lord Wilberforce can now be regarded as authoritative in setting the proper limits of the type of extensive interpretation now under consideration. And there's a reference to giving effect to a plain parliamentary purpose. And that doesn't mean that because newspapers fulfilled a purpose that anything else that does can also be included. And I don't think there's anything in Lord Hoffman that we need to refer to. So at that point it may be helpful.
But I mean,
if I pick up
you
the-
say, I mean, when we're looking at 25 there, where Lord Steyn says, in order to give effect to a plain parliamentary purpose, the statute may sometimes be held to cover a scientific development not known when the statute was passed. And of course, that's obviously right. If the development is within the meaning of the word as it was then used. But what you say here, as I understand it, is that this is a completely different concept. The taxation of services is something completely different from the taxation of goods in VAT terms. That's clear from the whole structure of the European legislation.
Materially different.
Sorry?
Materially different.
Yes.
There are some similarities.
Well, of course there are similarities. The tax is the same tax. But the point is that it's not equivalent to a scientific development covered by the word when you're talking about the difference between a physical object printed on paper, which is what the legislature was talking about, and which is sold from one person to another as a physical sale, the supply of a license to read something electronically, which is not sold at all, and is provided to you as an opportunity to look at information on a computer screen. I mean, the whole thing is a different concept. It's not an electronic invention of a newspaper, it's a different thing.
The only one that gets close to it would be the PDF of a newspaper, but that itself is a you have to wait till you print it out.
Well, the PDF of a newspaper is not the same either, but for the same reason that I've just given, because
I agree.
it is a service. You have the right to look at information on a computer screen under a license, provided the material is provided electronically. There is no sale of a newspaper, as one might say, drawing on something that my lady said to me the other day about people driving newspapers around in vans in order to get them to the point of sale, putting them through printing presses and loading them all up in great big bundles. That's the process of production and then sale of a newspaper. But the production and sale of an electronic newspaper is a completely different process.
And what was said back in 1972, I think it's in the bundle towards the end, is one of the reasons for including newspapers was to support the ailing newspaper industry in the last part of the 60s and into the early 70s.
Yes.
It meant everybody, including the van driver.
which some of us are old enough to remember, the strikes in this was that period, I think.
We were about the same time as, well, there was.
I think the Times,
Well,
the Times had a
yeah,
strike.
well,
That was later,
That was
that was
much
when they
later.
moved.
That's
That was
that's
the
another
80s,
revolution,
yes.
wasn't
The winter
it?
of
It was-
discontent,
because
yeah.
in 1972, the production of newspapers was hot metal, wasn't it? It was
Fleet Street.
It was,
Yeah, no,
Print.
that's
Yeah.
exactly.
and then there was the revolution in the 1980s when it all
Yeah.
Moved to
became
Canary Wharf.
when it moved to Canary Wharf, but they stopped printing it in that way, and it was all
Oh, Wapping.
Wapping.
Canary
they,
Wharf, sorry.
they printed it using word processors,
Yes.
and
And that was when the
printers.
strike took
That was
place.
when the
Yeah.
strike.
Yes, it's true.
So they-
Somewhere in my drawer I have the last, what would have been the last edition of the Times. Sadly, it was reprinted again a few months later.
So I mean,
But
my
no
ladies.
one would have argued that that wasn't a newspaper. The fact that it had been printed in a even if the wording in 72 had said printed newspapers,
Yeah.
at a time when all that was contemplated was with metal letters, by a
It's still
compositor.
printed when it gets to the shop.
it's still printed, yes. So that technological development would not have prevented it still being a newspaper.
I mean, just for my benefit, because my ladies are quite satisfied that this all took place in the 1980s. My recollection is that it took place in the 1970s. And
No, because I
When-
wasn't
when-
in this country
Right.
then.
What
but
I meant
was
is
in
the
this
long
country
strike.
in the 80s.
Long
Yeah,
strike.
the long
No,
strike.
80s.
is in the
80s.
90s.
Definitely
Okay.
80s.
All right. I stand corrected.
Mainly
Murdoch moved
right.
printing to Wapping
Yeah.
and introduced new rules for the printers.
In
Yeah.
which year?
I think it was, I'll check, I believe it was 81.
Yeah.
Okay.
that's-
Thank you
that-
very much.
I will
Well,
check the accuracy.
But the
I was
strike
thinking of
has
another
changed
strike.
with
Me.
that.
I was
Because
thinking of
well,
the
I'll
other
tell
strike
you
for the post.
when I remember it.
I was thinking of the photo printing strikes, which I thought were the 70s. Doesn't matter.
Anyway, but it is interesting for it's interesting for the reason my lady gives, because the distinction then was in the way the newspaper was printed and produced actually on word processors, which were then printed by electronic means, but the actual good, the outcome of the printing process remained the same at that stage.
Yes. And all the way up to the 90s, I don't even need to bring it up to date. Anybody reading these provisions would be considering printed physical documents. And again, the complaint is from the Upper Tribunal, is from a learned friend. If Parliament wanted to exclude the digital versions, it should have used the word printed back in 1972, or added it in 19 now. That we say is, very respect, not a sensible way out of this.
Well, we were at paragraph 25 of Lord Steyne in Quinterbell, and I'm afraid it's my fault because I drew attention to the penultimate sentence in that paragraph.
Well, no, it takes me neatly, I hope, to the case you wanted us to look at, which is the FII case,
Yes.
which if you don't have physical copies, they're now in your folders.
You'll be pleased to hear I have an electronic copy.
Well, you can get more quickly to paragraph 218. In the majority judgment, Lords Reed, Hodge, Carnwath, Lloyd Jones and Hamblin, the only reference we could find, and it's in the email to us, in that judgment is 218 and 219, which has helpfully set out what I've been getting close to writing an article called Always Speaking the Vague Expression. And now we've got it in the judgment. Third lines down, that somewhat vague expression is commonly used in connection with statutory terms which change in their connotations over time, family, bodily harm, etc. The always speaking principle is also invoked, and the question arises whether a statutory expression should be interpreted as including a novel invention or activity which does not naturally fall within its meaning and was not envisaged at the time of the enactment, but which may nevertheless fall within the scope of the original intention. That's the reference to document and the embryo in Quinterville. And we get nothing new from that save the reference to the vague expression. What we get in 2019 is, first of all, the question in the present case is not of precisely the same kind as where the 32(1)(c) of the Limitation Act does cover mistake of law. The question therefore arises, this is the last sentence, where section 32(1)(c) applies to those unforeseen circumstances, a question which ultimately boils down to the same issue as arises when considering the always speaking principle. Indeed all cases concerned with statutory interpretation, what is the construction of the provision which best gives effect to the policy of the statute as enacted? Well, of course, the policy of the statute as enacted in part is to promote literacy and to further information, but it's also a conservatory provision where the policy is to exclude from tax certain items.
Well, it's to take advantage of the permission given by the EU to retain zero rating.
Yes, that's the policy, the overall policy. It isn't to isolate the purpose, which is a requirement of Article 110 in any event, is not completely to state the policy. The dissenting judgment begins at page 100 of paragraph 258, Lord Briggs and Lord Sales, and the consideration of always speaking begins at 268. Could I just look at this and then perhaps invite you to rise? 269 is, again, it's difficult to attach too much to these paragraphs because, first of all, it's a dissenting judgment, but also, as they say at the end of 268, nothing really turns on this. But there you go. The guidance regarding the ambit of the always speaking doctrine is in fact concerned with the fundamental underlying issue of whether Parliament can have intended by a statutory provision passed at one point in time using language directed to the circumstances at that time to cover a new set of circumstances. That seems to be common ground. The issue of how broadly, missing out the reference to Kleinwood Benson, the issue of how broadly one should construe the language of the statutory provision cover new matters arising after its enactment necessarily involves consideration of what inferences can be drawn from the language used and the circumstances of the enactment as to Parliament's policy intention in promulgating the provision. All of that is what I've been talking about. If the inference can be drawn that Parliament's policy intention was broad, no, it wasn't, and the new matters are aligned with that broad intention and are covered by it, the court will be justified including the provision applies. Conversely, if there is not sufficient congruence, goods and services, between the policy issues raised by the new matters, Parliament's intention as expressed by the enactment of the provision, then the provision does not apply. And not only is it conservatory, it's subject to the other two restrictions of it's fixed in time by Article 10, also it is subject to the strict interpretation. And in 270 there's again the repeat of Lord Wilberforce in the Royal College, and it ends with a reference on the same page to not only to Quinterville but also to Crown against Ireland. Statutes dealing with a particular grievance or problem may sometimes require to be historically interpreted. So that is, we say here, perhaps, helpful in saying that this is zero rating and must be treated as such. The rest of the paragraphs, 274 in particular, takes me to just one other reference. This is all really picking up Lord Wilberforce. At the top of page 108, my Lord, if you're online it will be in paragraph 274 Roman 3. It is clear that this particular provision, that's the one that was designed to be restrictive and circumscribed in its operation rather than liberal or permissive. And we say exactly the same applies to zero rating. But Lord, would that be a good moment to rise?
Yes, I think it would. We'll resume at 2 o'clock. Thank you very much, Mr. Fleming.
All right.
Another 45 minutes? If I can't do you on sub one first.
It takes a bit of explaining in that case.
I'm a marinara man myself.
I expect you to have full information about exactly how it's cooked.
I never understood if the marinara was a toasted sandwich or some other kind of food. Heavenly to hear it.
So they should have it by now.